The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we'll discuss the various methods for evaluating the validity of a mechanic's lien in Illinois. We'll cover topics such as the proper prerequisites to a mechanic's lien, the difference between contractors and subcontractors, and the work that must have been done to satisfy a lien, information necessary in a mechanic's lien, and deadlines associated with filing a claim. So the prerequisites for a contractor versus a subcontractor lien differ somewhat, but the basic stipulations are more or less the same. So prerequisite 1 is the claimant a contractor or a subcontractor. So in order for a mechanic's lien claim to be valid, the claimant must be defined as contractor or subcontractor as described in the Mechanic's Lien Act. This act essentially defines a contractor as a person who enters into a contract with the owner of the land or property in question for the purpose of improving or maintaining the land or structure. A subcontractor is one who contracts with the general contractor to do a portion of the work but is not privy to the contract between the general contractor and the owner. A first-party materials provider to the general contractor may also be considered a subcontractor. Simply stating that one is a contractor or subcontractor, even in the terms of the contract, is not enough to establish proof when reviewing a case. The facts of the relationship must be examined in order to establish what role was actually played. Prerequisite 2. What does the contract state? The burden of proof is on the lien claimant to show that he or she has a contract to support the claim. Under the Mechanic's Lien Act, the contract can be written or oral. However, a case based on an oral contract may be harder to prove. Ultimately, the written or oral contract must exist in some form and support the stipulations in the claim. The contract must be legal and not void due to some violation of law or public policy. For example, a lien from an unlicensed contractor would be unenforceable. So prerequisite 3, who is the contract with? So in order for a lien claim to be valid, it must fall into one of 3 categories. It must be a contract with the owner, and depending on how the property is titled, the business situation, how many properties are involved, the owner of a business can sometimes be ambiguous. However, if the contractor does his or her due diligence, it should be clear at least who the owner is in name, whether it's an individual or commercial entity, bank, or something else like that. Then the next thing is the contract with an owner's authorized agent. Here we have an individual or entity who has the authority to act on behalf of the owner. It may not always be apparent that an individual is an authorized agent for a given piece of real estate, and often it falls onto the court to make the determination. So, like for example, if multiple individuals own 1/2 undivided interest in a property and another person owns the other 1/2 undivided interest, the latter individual's actions can be considered those of the authorized agent for the whole group. Then we have knowingly permitted by the owner. So this is an individual who has the permission of the owner to contract work on a property. This permission doesn't have to be in the form of a written contract as long as it can be proven in court. For example, if the owner of a building knowingly allowed a tenant to contract work for improvements, the lien against the tenant and the owner would be valid. So prerequisite 5, did a claimant provide lienable labor or material? So the key word when asserting a valid lien is improvement to the property. Did the claimant actually improve the property in any way? The Mechanic's Lien Act goes into great detail when defining improve as it relates to work done on materials provided by a contractor or subcontractor. When considering materials provided, it is not necessary that the materials actually be incorporated into a structure for a lien to be valid, but rather must have at least been delivered and knowingly received by the client. Prerequisite 6, did the lien claimant finish the project? So a contractor must have completed the work set forth in the contract or be able to show that he or she, in good faith, made the greatest attempt to complete a substantial portion of the work agreed upon in the contract. If the appropriate amount of work was not completed, the contractor must be able to provide a valid excuse for non-performance, such as like the owner excusing the contractor from a work site, making it impossible for the contractor to actually finish the work. Evaluating all the prerequisites for a lien is the first step in defending against a mechanic's lien. Beyond the prerequisites, there are a number of other factors associated with a proper mechanic's lien. These are going to include things like timely perfection of the lien, the specific requirements of a general contractor, evaluating the time period surrounding the work done and the claim, and then proper information recorded in the lien. Then you've got verification of the lien. There's also going to be description of the property. Then there's time frame associated with the lien and the claimant. And then there's going to be just a number of other ones as well too. So for more information on mechanic's lien in Illinois and the Mechanic's Lien Act and the applicable deadlines, check out our other articles and videos on Learn About Law. As always, thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.